I'd love to welcome everyone back for panel 2 and to introduce the moderator and the panelists. So to my left, we have Jenya Turner, who is the Amy Abud Ware Centennial Professor in Criminal Law at SMU Dedman School of Law, where she teaches and writes about criminal procedure and comparative criminal law. To her left is Rachel Rollins, the District Attorney for Suffolk County, Massachusetts. She's had a long career in public service, serving as an Assistant United States Attorney in Boston and, among other things, as the General Counsel for the Massachusetts Department of Transportation and the Massachusetts Bay Transportation Authority. And again, Dan Satterberg, who is still the prosecuting attorney for King County.
As of right now, right?
And further down, Satana DeBerry, who is the district attorney for the 16th Prosecutorial District in Durham County. And she has a diverse background that includes criminal defense work and working to expand access to resources for marginalized and underrepresented groups. And she has never been a prosecutor before becoming an elected one. To her left is Andrew Crespo, who's the assistant professor of law at Harvard Law School. And before becoming an academic, Andrew was actually a staff attorney with the Public Defender Service for the District of Columbia. And then all the way at the end, and last but not least, is Steve Zeidman, who's the director of the Criminal Defense Clinic at CUNY School of Law and a professor there as well. And he has over 30 years of experience working in the area of criminal defense.
All right. Well, thank you, Courtney, and welcome everyone. I'm very excited to be moderating this panel, and I'll just dive right into it. And the first question I wanted to ask the prosecutors on the panel is whether the question of plea bargaining and the various concerns that we heard about plea bargaining in the first panel, whether that's something that came up on the campaign trail. Is that something that the public is aware of? Dallas just had a contested DA election, and it's not something that came up in that campaign. Issues of pretrial detention came up, just generally issues of prosecutorial discretion and diversion and charging decisions came up, but not plea bargaining as such. And I was just wondering what your experience was, and that will give us a sense of, is the public aware of these concerns that we're discussing here? Dear Rollins.
Okay,
Yeah.
here we go. I would say we were fortunate. We had 5 really strong Democratic candidates. One, like the fabulous woman to my left, who was a public defender her entire career. We had a couple of prosecutors, and then myself, who has sort of done many different things. She started the conversation a lot about plea bargaining. And I think in Massachusetts, in Boston, Suffolk County, we had a lot of people that had no idea that our DAs were even elected. The ACLU had done an amazing campaign called What a Difference a DA Makes that was really active in our area, in our Commonwealth. And we had a wonderful gentleman there, Rasan Hall, who was educating people as our campaign was going on. So it was touched on a little bit. I don't think people have any idea how important this issue is, or did when we were in the process of campaigning.
Yeah, I think the short answer for me in my campaign was no. There's no plea bargaining on television. So what people are really familiar with are what they perceive to be jury trials on Law and Order. And that's about it. Now, in situations where I was mostly talking to lawyers, there was some conversation about the plea bargain. But I would say also that criminal defense lawyers, whether they be public defenders or private lawyers, are very comfortable in the plea bargain system as well. So to kind of push against it is a new concept.
And I'll say that there's a lot of talk about criminal justice reform, and there's a broad menu of things that people talk about. But the last hour that we spent here in this room was the longest I've talked about plea bargaining ever. And I've told you everything I know about it. But I want to say that I think it's important. I think it's really important. And it's one of those hidden things that's part of the internal system, the internal engine of the criminal justice system all around the country. And we rarely lift back the hood and look at the engine.
Okay. So I want to pick up on some of the issues that were already raised in the first panel, but want to see what this panel thinks about this. And key concern about plea bargaining is coercion. So this came up in the prior panel, and that plea bargaining can be abused to coerce defendants into a plea deal. So, you know, whether you call it a significant plea discount or a trial penalty, that an innocent defendant may be coerced into pleading guilty, and also that an enormous, if you call it a plea discount, can disserve victims in some cases. So we already started talking about caps on plea discounts or the trial penalty, but I wanted to hear from this panel also, what do you think about the possibility of a cap on the trial penalty or on the plea discount? So for example, what if the law tells prosecutors, if you have offered to recommend a certain sentence as part of a plea deal, then that should be recorded, and then if the plea deal falls apart and the case goes to trial, that you may not recommend a sentence that's, let's say, more than twice that of the offered plea deal, or more than 30%, you know, whatever the plea discount. I'm just curious what your reaction is. Is that feasible? Is that something you'd be open to? So let's start with DA Rollins.
Yeah, I mean, I actually would be open to that. I feel like a lot of people don't understand, of course, pleas are tied to charging decisions, which if we're overcharging people and then offering them a plea later to say that 13 things we charged you with will knock off 11 if you just plea to these 2, well, wait a minute. The whole judicial system or the whole process of motions to suppress or anything else are supposed to be checks on the police. And when we plea, those things usually don't end up happening. So I issued a memo for my office about what my vision is going to be for the next 3 years, 8 months, and 42 days, or 16 hours, or whatever else I have left on my term. But just to say, overwhelmingly, if a plea was offered at one point, we're not going to penalize people for exercising their constitutional rights. Now, there are certainly circumstances where if a victim has to get up and testify, we made it clear that there are going to be things we take into consideration, but I would certainly be open to that, yes.
DA Seiderberg.
Yeah, I've said, I think it's a good idea. That is not the same thing as saying that my office follows that rule. That's why they hate to let me go to conferences like this, because I come back. But I think that to the extent that there's something bad about plea bargaining, it's all done behind the scenes in the shadows. And if we were to put it out there and just say, here's what the case is worth, here's the maximum justice value, and we're not going to exceed that, even if you go to trial. If we played within a range like that everybody knew about going into the case, that would be an improvement.
And the last thing, I'm sorry, we require, the memo says you have to write it down. You don't have to put it in writing, but it must be written and recorded on the case file, and who was the lawyer you dealt with. Because I've only been in my job 3 months. I can't tell you how many times a criminal defense attorney has told me, we were offered X, my office says, no, I wasn't the ADA on that, but 8 ADAs ago, I don't think, and when it's like, what is happening? What is the answer? Let's just see what the answer is.
And that's, before we move on, that's actually something critical is there a written record somewhere? Because I did see your memo, and I was very pleased to see that you had that in there, memorializing
thank
the
you.
plea deal. And just wanted to see what the rest of you think about that. Is it feasible? I mean, these days, for example, again, speaking about Dallas, everything is done on a digital platform. So the digital platform allows DAs to just put in such and such plea was offered. So it's really not that difficult to memorialize it, at least, you know, what I'm familiar with, but I'm just curious what the rest of you think.
I would say yay for Dallas. I beat an incumbent, and so same thing, we get criminal defense attorneys who come and say, hey, at the transition, we were at this on plea, and there's nothing written in the file, right? And so that is really challenging. We don't have that kind of digital system. One of the things we have begun to do is require that these plea offers be written, which seems like a very low standard.
Right.
But you'd be surprised how often it doesn't happen. And it also helps us long-term gather data.
Of course.
Back to kind of the original question around capping plea bargains, I'll give you an example of me facing this in actual real life. So last month, one of my commitments was to actually use jury trials. I think one of the reasons we use so many plea bargains is we have prosecutors in the office who are afraid to try cases. And so I was really clear when I was hiring for my office that I was hiring trial lawyers and that I was creating trial lawyers for the folks that I kept. And so every month we've tried a first-degree murder case since January. And the challenge has been for me, last month we tried a first-degree case. I inherited almost 100 homicides pending trial. Some of them as old as 2013. In my jurisdiction, the incumbent and his predecessors tended to charge everything as first degree and then negotiate from there. And so we had a case in which it was charged as first degree. We were proceeding to trial on first degree, but had offered the defendant second degree. Real quick, over the facts, it was a 19-year-old kid. He thought another 19-year-old kid was stalking him. Neither one of them had records. It was a really bad case. He shot him from across the street with a high-powered rifle in the back of his head. It was a tragedy. Like, could not have been more of a tragedy. And these two kids had no interaction with each other than social media, somebody saying one had talked about the other type of thing. So I lost a lot of sleep over the weekend before we went to trial and during the trial because the defendant asserted that the homicide was justified. And I offered him second degree the weekend before. He didn't take it. What he was facing was life in prison. It's hard to sit with a family who's lost their child in really kind of what looks like an assassination attempt, and say, hey, I don't think this guy really deserves to be in prison for the rest of his life. And it's especially hard for me because in my jurisdiction, all of the victims' families, all of the people left behind are me. They literally are the same age as I am. They look like me. They're all mothers of black children, right? So I have to sit there and talk to somebody who I know where she comes from, what she's dealing with, and tell her. But on the other hand, all of the defendants' mothers look exactly like me as well, right? So it's a challenge. Now, I think it worked in this situation because the jury came back with voluntary manslaughter, and that was the exact right decision. So juries can, he got the gold standard of American criminal jurisprudence, right? Which was a full trial where he got to assert his innocence or his justification, and the jury got it right. And so I think we need to proceed more to trial on these things because the juries do, I think, get it right most of the time. We just have to have faith that that's going to happen.
Yeah, and this is not the same panel, but in Boston, we need to make sure we have diverse juries, number one. And similarly, one of my first decisions I had to make is a 14-year-old and a 16-year-old in a joint venture murdered a 16-year-old. And the 14-year-old was the one who lured him there. The 16-year-old was the one that shot him. I've instituted that when criminal defense lawyers want to negotiate or discuss pleas in homicide cases or other serious cases, I'll meet with them. Now, my ADAs are in the office with me, but we ended up making a decision that I think was fair, but Game of Thrones is starting soon, so I like to say I'm Ned Stark. I then said I want to meet with this family who's lost their 16-year-old son and is going to be possibly unhappy with the decision we made about the 14-year-old, which I believe is different than what the 16-year-old did. But yeah, overwhelmingly in the Washington Post, if you've read the article, Boston has the largest race disparity in the country with respect to solve rates of homicides. So every family I go to, overwhelmingly, is me as well.
So-
Jenny, can I just jump in real quick?
Yeah, I was actually going to go down and see if
Oh.
both Andrew
Andrew?
Crespo and Steve Zeiden have.
Yeah, I just wanted to say, and I think it's important just at the outset, when you put the question in terms of law or policy, from my perspective, it's very different. If it's law, perhaps we can talk about plea caps and what that means. When it's policy, it's problematic, it's troublesome. You know, present company accepted. The concern, you know, from my perspective, we heard the first panel. There's too much power vested in the prosecutor. So the question is, are we going to focus on that problem by saying, making sure officers wield that power more kindly, more thoughtfully, more gently, or we can say, let's redistribute the power, or we can say, let's cede power. So we're right now in this point of, you know, doing it more kindly, more thoughtfully. To me, I don't think that gets, from a national perspective, really at the core of the problem.
And I would just say back, because this is who I am, get ready. Now that the prosecutors look different, now that they're women, now that there are people of color, I find it hilarious that miraculously all this discretion that prosecutors had when it resulted in mass incarceration, no one had a problem with it. But now that people like you and I are stepping up and saying this is going to change, people are like, whoa, you guys have so much power, let's, no.
Ditto, ditto.
Andrew Crespo, did you want to add something about plea discounts?
Yeah, to your question on plea discounts, I mean, so we heard some powerful arguments in the first hour about sort of maybe what an abolitionist world would look like. But I think shy of that, putting some constraints on the plea differential is the most sort of significant policy lever you can get to rein in plea bargaining. And I think when we talk about reining in plea bargaining, we have to realize that what we're talking about is the primary driver of mass incarceration in the country, right? So if there is this emerging consensus that there are too many people in prison, and we know that they're almost all getting there by pleading guilty, then some way of reining in that plea rate has to be part of a discussion about putting the brakes on mass incarceration. And I think that leveling that differential is the main way that you're going to level that playing field. I think one thing that D.A. Rollins said that I think is really powerful and important to underscore is when we talk about these gaps, we have to realize there's different types of gaps we're talking about, and some of it is on the sentencing and the years, but a big part of it is on the charges. You know, and the example she gave was, and I heard it as an example of a problem. You charge someone with 13, you offer to trade away 11, and that's the massive leverage. I suspect, just thinking back to my own days practicing, that many of these cases where someone's charged with 13 is not because they are being charged for 13 robberies. They're being charged for one robbery 13 times. And you know, I think that the public, to your first question, when they think, what do they think plea bargaining is, that surprises them. When you hear this person, you know, got arrested for a robbery and there's an indictment that thuds on the table and has 13 counts in it, the public would think you charge them for the crime. But actually what happens is you charge them for the crime 13 different ways and then offer to trade away 11 of it. So that's the spot in which the prosecutors actually have the most tremendous power and leverage, because those different charges can carry some mandatory time with them. So if we think of it not just as putting a cap on or some constraints on the number of years that are being discussed, but the way in which you're able to both inflate the number of charges and then trade them away is, I think, one of the most important policy levers in this space.
So this is a great transition to my next question, which is about the role of guidelines, and also Steve's earlier point about policy versus law, the role of guidelines, and then the role of procedural law, which I know that Andrews has written about, in constraining discretion, charging discretion of prosecutors. So to the prosecutors, I'll start with the question about guidelines. Are there any guidelines in your office, or do you think it would be a good idea? And I know some of you have talked about this, but what guidelines are there in terms of your charging policy and whether and plea bargaining, any plea bargaining guidelines, and how are those enforced? So not just what the guidelines are, but how do you enforce them with your line prosecutors? So if you can talk about that, and then maybe if Andrew and Steve can talk about, can the law do something to contain charging discretion? Are there procedural rules or other rules that can constrain charging discretion?
So part of what I ran on was, after meeting with tens and tens and tens of public defenders, former prosecutors, sitting judges or retired judges, people that have actually touched the criminal justice system, was just a list of 15 crimes that in the first instance we weren't going to prosecute. I spoke about it as a candidate. We memorialized it finally in a memo that I did. So there's an outline of with respect to these charges, how we will handle them. And there's different buckets of you've never been in trouble before, you're charged with one of these 15 low-level, nonviolent sort of crimes, you're dismissed outright. And then the next bucket is, maybe you've done this once before in the last 3 years, maybe we have a diversion pre-arraignment. And then this bucket, whatever. And then there is language with respect to plea negotiations in the memo as well. The memo only came out a week and a half ago. Part of what is important to me is, like plea offers, policies that aren't written down. It's really easy, you know, I don't know how many employees you have in your office. I have 300 people I'm responsible for, and those are the ones that I pay their salary, but they're, you know, my homicide unit in the state police, my Boston Police Homicide Unit, you know, I have a children's advocacy center. I have about 450 people I'm responsible for, roughly. If things aren't written down, how am I, as the DA, to know whether they're implemented or not? Part of why I wanted to write it down is I wanted to, these are guidelines, but I want it to work the same for everyone. And what we're doing is we're not only just issuing this memo, we're training people on it, and then when they're not complying, we're gonna correct, and if they don't want to any longer, we replace.
And when you say if they're not complying, so is there a supervisor checking on whether they're?
Yeah, so part of so the way that we operate, the overwhelming majority of the things I'm proposing are in our municipal and district courts. We have a chief of district courts. And what that person is gonna do, they're gonna have 2 deputies, they're responsible for sort of overseeing all of this. These are guidelines. At any point, if an ADA thinks, no, I don't think this is right, they're to go to their supervisor and get permission to, you know, sort of step out of the lane of what the presumption is. And they can always do that, and we encourage them to. So some of those things require not only a supervisor saying it is okay, but a notation that a supervisor in fact did that with the supervisor's name and whatever else, that the discussion was had, and this is why we are diverting from the presumption. So yes.
So for at least 30 years, the King County Prosecutor's Office has had written filing standards. It's a dynamic document. We amend it all the time to reflect the things that we are not gonna charge anymore, the things we're gonna divert, but everyone's got it. The defense attorneys have it, judges have it, and if somebody is negotiating a case and they think that our deputy prosecutors are not following the guidelines, they can point out right there why they think not. I mean, so it's important just to put it out there, but it isn't self-executing. It depends on people of good faith using good judgment, and really the culture of the office is equally important as your written guidelines. But they are presumptive, and they can be overcome by, if we can articulate a reason to not follow them, but most of the time it does guide our decision, and I think it's important to have.
And you think there's sufficient supervisory review all along between line prosecutors that they are followed, and sufficient written records of what pleas are offered, what charging decisions are made, that can be checked?
I think during that process that, yes, we follow the written standards, and there's always a supervisor who's willing to hear the complaint, and I'm the ultimate complaints department if they don't get what they want.
So we have some written policies, we're rolling them out over time. But the way that we've dealt with that in my office is each prosecutor is assigned to a team. Each team has a team lead. The team leads meet with me weekly, and we don't have a regular time, but each team actually gets some time with me where we talk about the plea bargains. And the idea is that they start to understand from me the way that I think about these cases, and that they start to implement that themselves. And so for things like status offenses, you cannot charge a status offense unless you have actual permission from me, not your team lead. And so that's the way that we kind of work on some of these outliers. We've also provided defense attorneys the opportunity to provide mitigation packages to the team, as well as if they don't feel like the plea offer that they've gotten represents the case, or for whatever reason, they can come back to the team lead and then appeal that to me. But usually by the time it gets to me, at this point, you know, it's about culture, it's about who you've hired. I try to have them all think with my brain, which I apologize to them for that. But usually by the time it gets to me, they have given the offer that I would have given. And we've had a couple of situations where we've had issues. We didn't really have a transition, so I just kind of inherited all of the cases. And we have issues where people were offered things that I would not offer, but we go ahead and approve those. But I think we're working in a way that we're all starting to think about this the same way. And I think that's the most important piece. We may differ, and we're gathering data, and so we'll see how far apart we actually are when we're doing it, but that's what we're doing.
Okay, and Andrew Crisper, you've written about procedural law being used to constrain charging discretion, so if you can talk about that a little bit, and whether you think that's a way to constrain some of these abuses that we've discussed.
Sure. I mean, one of the things that's striking listening to all three of our head prosecutors speak about this is the challenges of getting consistency within an office and to get kind of everybody online. You know, when I set out and look at this kind of across offices, across states even, it's striking how different plea bargaining can actually be in practice, which is one of the biggest surprises that I sort of uncovered when looking into this, that we talk about plea bargaining kind of like a monolith, but there are states that have plea rates around 86%, 87%. I think New York's plea rate is around that high. There are states that have plea rates down in the 50s. What's the key difference? They actually all have the same trial rates. Their dismissal rates are totally different. There are states where there's a dismissals up in the 35-40% range, and states where dismissals are in the 6-7% range. Now, a big part of that may be things like office policy and office culture, and that actually electing new DAs, as we're starting to see across the country and in this room, has a big impact on how that shakes out. But one of the other things that's really surprising is that the law around this stuff varies dramatically from state to state. It's a law that we don't spend a lot of time talking about because it takes a long time to learn what the law is in one jurisdiction, let alone 50 or more. But things like whether or not you have a right to a preliminary hearing, or whether that's something that can be bargained away. Anyone who's ever tried a case knows that if there's a preliminary hearing in the case, that's a key moment when plea bargaining and the offers kind of get attention focused, and there's a better offer before one than after. Why? For some of the reasons we heard this morning. It's a lot of work to prepare for these. You have to call in witnesses, and if part of what plea bargaining is supposed to do is save time and save some efficiencies, when you get past those key procedural moments, that's going to be an important part of how your plea bargaining shakes out. That means that whether or not these are things that are easy to waive away, or whether they're more written, concretely in your local law, so that it's a fixed part of your system, is going to affect how bargaining grows up around all of that. So there's lots of key points at which our procedural rules control things like how easy it is to actually charge 13 crimes for one offense versus charge one crime for one offense. How easy it is to amend these charges and actually sort of glide path down from a really high, thick indictment that thuds on the table to one that's much lower. So I think that it's both office policy and culture, but we also have to remember, as Steve says, that this is operating within a legal framework, and that the people who are writing these procedural laws actually have some substantial control over the costs that are saved by plea bargaining, and as a result, how attractive plea bargaining might look.
And just before we move on, can you give examples of specific jurisdictions that are getting this right in your view? So whether with respect to preliminary hearings or with respect to charging dismissals and amending charges and so forth.
So the short answer I'll give is that I have a much longer answer that has sort of this is drawing from work that I did a year ago, an article that has an appendix that's about as long as the article, and the appendix sort of maps through and tries to show out where all these different states land. One of the things that I'll just say is that surprises me is that it may not line up the way that your popular conception might be. So, for example, the state of Texas, which when I set out to do this, I did not imagine to be the paragon of liberal criminal justice policy. Actually is, on these levels, has quite a bit in terms of both discovery, in terms of charge stacking, in terms of your protections against consecutive sentencing. That is surprising to see. But there's actually sort of, when you zoom back and look, states all across the country that have at least parts of their procedural law that is, I think would surprise people who imagine how they think that the system works based on just knowing their own city.
And Jenny, if I could, real
Yes,
quick, to the charging piece, which is obviously so critical. But let me just give you one example. Here in New York, I think some people might be familiar with the issues around marijuana and legalization. And one of the things you run into in the legislature is this idea, in particular in New York City, is that there's a movement to legalize and that district attorneys have new policies and won't prosecute. And you speak to some of the practitioners in the room, even in the jurisdictions where that seems to be the policy, they will tweet that same day, I'm in arraignment and someone is being charged with marijuana. Or you can be in Brooklyn and then walk 2 blocks and you're in Queens and there's a different policy. So while that matters greatly, ultimately, from my perspective, these sorts of decisions, we need a legislative fix. You legalize marijuana, this problem disappears.
So, and by legislative fix, then you mean decriminalizing some of these?
Legalizing.
Right, legalizing some of these currently low-level offenses.
Correct.
Well, I push back on that. I mean, I think in Colorado, they're actually charging more black and brown kids with marijuana possession than before legalization. So that's it.
Yeah, and what else is interesting too for me is when we talk about pleas, we haven't touched, I mean, everything touches, but if you're sitting in, if you're incarcerated and you don't have money for bail, let's add that, you know, that 40-pound weight or 400-pound weight on your shoulders in addition to 15 charges of the same exact crime, but you're looking at something. I mean, I'm a lawyer, I'm your DA. Sometimes reading a BOP is like, what? What, does this go back to this date, or when did it start? We call it Bureau of Prisons, or it's the III, or whatever you call it in your place, Carrie, Corey. Those are really hard to read, and forget about just the criminal justice system. If someone's looking for housing and has to have their credit report run, or they run a criminal history, do you think the person who's managing the real estate development, if the DA can barely read a Corey or a BOP, do you think they're like, well, on page 17 it said it was dismissed? They're like, next potential renter, please, right? So, so we have a lot of different pieces in the system that are leaning down on people to plea.
And preliminary hearings are a great idea and hard to make happen. So I live in a state where you're provided opportunity for probable cause hearing at the district court level on a felony. And one of the things I talked about in my campaign was actually staffing for probable cause hearings, so being available, having my attorneys, whenever a defense attorney calls for a probable cause hearing, ready to sit down and do those. And hardly any of them ask for them.
Mm-hmm. So that's, you know, there's, I think, an important thing to talk about here, which is exactly that, the culture of defense offices and the culture and how much variety there is on that, right? Whether you have an actual office or whether you sort of rely on a kind of more diffuse bar that maybe has a whole different set of incentives or supports for that sort of thing. So, you know, there's a way in which an extended, at this point, decades of not funding the other side, your adversaries, right? Not supporting a kind of organized, institutionalized defense bar, you know, across the country. Yeah. Means that sometimes when you have things like this where you kind of, the whole reform is built on the assumption that of course this person's lawyer is going to take advantage of these policy changes, that many times that ends up not happening. You institute this and then you don't get the reaction we might expect because we imagine sometimes that there's actually a robust adversarialism when in fact there's nothing on the other side, right?
Sure.
That there's no, they're either, the attorneys are drowning, they can't prep for the preliminary hearing because they're representing, you know, 500 people and have 7 minutes for a case or something like that.
Well, I will tell you the truth is that the prosecutors can't prep for it either, right? So we talk a lot about public defender caseloads. My prosecutors have bigger caseloads than public defenders. In my jurisdiction, we have opportunity for there to be private attorneys who take some cases. The public defender only has about 60% of the criminal cases. The rest of them are with the private bar. But my prosecutors own every one of those cases. Yeah. I have drug and property crime. In my drug and property crime unit, I have prosecutors with 500 cases. And so the requirement to know every one of those cases and to be able to do a probable cause hearing on every one of those cases is a problem. So I've got,
Can I add a footnote to the defense piece, which I think is just, this is obviously, we're focused on prosecutors, and I guess the next panel, judges and legislatures, but it's not only under-resourced defense lawyers, but and I say this with great caution, because we're talking about, I know where the power lies, but we should be talking at some point about the role of a defense counsel in plea bargaining, and by that I mean the nature and extent of the advice that they're giving. What is effective assistance? We can go into any office in the country, any public defender office, the best public defender offices, there'll be some lawyers who try 10 cases a year and some who try none. And what is the issue? What's going on there as well? So it's a missing piece that we should surface at some point.
And to be frank, this conversation is about the disruption of thousands of independent systems in different counties, most of which are quite comfortable with where they are. Don't feel this urgency that we have to blow something up that works for them. Everybody gets to go home by 4:30 and, whatever. The judge is going to be able to crank through all these cases because they're not all being contested like it's the biggest case in the world. So that disruption, every county's going to have to decide sort of how much of that they want to internalize, because there will certainly be a lot of pushback from people who say, everything's working fine, we don't need this.
Yeah,
Right,
that's,
I have
that's
to-
happening right now with me. So, yeah, we are absolutely disrupting 100% in Suffolk County because it is working for people that are wealthy and not for overwhelmingly people that are not. And what I know I interrupted you, I'll let you just go on.
no, I would say I've got district court judges who say you have to declare a probable cause hearing by 10:30 in the morning, court starts at 9. If you haven't, so which gives neither the prosecutor nor the defense attorney the opportunity really to look at the case file, because we have a local rule that you only get 120 days in district court. And so my prosecutors may not get the felony report until we're past, it's a whole thing. But, judges want to be out at 12:30. And they control the courtroom. I don't control the courtroom. So, and they throw back. We try to do really disruptive and progressive things, like plead felonies in district court. We have judges who send them back, who won't take it. If there's a gun involved, and, we need some judges on these panels too, because I don't know how many judges are in the audience, and I'm sorry, because I'm going to be really offensive right now. But I don't think a lot of them know the law, right? So they sit, even in our diversion courts, I've got a judge we have a mental health diversion court. It is a pre-adjudication court, which means everybody in it is only there because I want them in it. And I'm the one deciding who gets in it. But now the judge wants to have some decision because we had a robbery with a dangerous weapon person in there. And she's like, well, that charge is too high for this court. One, I don't care what you think, right, about a pre-adjudication court. I really don't. I know Dan's eyes just got like saucer egg.
Don't say that out loud.
I don't
Right.
say that out loud, but I mean, I do.
Well,
I don't
here you
really
are.
care what you think, but also it's my decision. And just because it's charged as robbery with a dangerous weapon doesn't mean that the evidence supports that, right? But we work in a system where whatever you're charged with, man, you must have done that.
Yeah. And the system, the point I was going to make is in Massachusetts, our public defenders only handle about 10% of the cases. Our bar advocates, which are paid by the hour, handle the overwhelming majority of them. And the system works well for them, right? Because every court appearance is yet another, payment. So there are many, many people making livings off of poor people overwhelmingly, and black and brown people getting caught up in the system with low-level crimes. And what you're seeing across the country is people that have come from those communities who are incredibly qualified to do the job saying, yeah, that's not happening anymore. And to reiterate my point, miraculously now we're going to start talking about prosecutorial discretion. So, and then the one other thing I'll say that's very interesting about Massachusetts, this is more about bail, and it's in our memo. I came from the federal system. Overwhelmingly, my prosecutorial background is as an assistant United States attorney. We had dangerousness hearings all the time, right? In Massachusetts, there are only 11 district attorneys. Some of those counties have dangerousness hearings all the time. Others don't. And so why, right? Like, for me, I think you're absolutely right. There are many people that are not interested in trying cases or love pleading them or having actual substantive hearings. And if we did have a dangerousness hearing and had to turn over information, I think it's very important that the defense bar see things early so that we can make better determinations.
So this is a good transition to my next question, which has to do with the connection between pretrial detention and plea bargaining. So partly earlier in the first panel, we talked about how kind of the deadline set by detention prevents maybe informed charges, fully informed charges, or the fact that there are no hearings maybe prevent that. But also, researchers have found that pretrial detention exerts enormous pressure on defendants to plead guilty to time served in misdemeanor cases in particular. So I was just wondering what you think about that, and what steps do you think can be taken to reduce the coerciveness of the current system?
You want me to take that one?
Yes, go
Go
for
ahead.
it.
Okay. I think pretrial detention is an important issue, and it obviously does for a lot of people, particularly the lower level crime it is, the more pressure there is for credit for time served. I want to go home. This is your chance. You want a trial? You can wait in jail for 90 more days. You want to go home? You can go home today. And that's a very, very powerful human instinct. And there isn't, they may say that they understand that there'll be collateral consequences in the future, but the urge to go home today is like, that's what the prosecutor has to offer right then. And that's how most municipal courts and low-level misdemeanor courts resolve their in-custody cases. The flip side of this, and the pretrial detention varies throughout the country. The Pew Foundation had a map on their website, which is really interesting. It has every county and their rate of pretrial detention, and the average American pretrial detention is like 208 people per 100,000. In my county, it's 35. We can't get the judges to hold anybody, and what happens is that somebody will be arrested finally, and they're a chronic car thief who's addicted to methamphetamine. The cops finally catch him. They bring him to us. We file a case. The judge lets him out the next day, and guess what they're doing? Because there's no pretrial services at all. They're right back doing what they were doing before, and now when we catch them, we've got 5 counts, not 1. So now instead of jail, they're looking at prison. So we really weren't doing them any favor by letting them continue to do their crime spree. And that moment, that day that they were in jail, didn't change anything for them. It just made them more hungry for drugs. So we have to think about, there's a downside to letting people out, because if they're engaged in that sort of conduct, they're going to come back and now they've tripled their jeopardy that they're looking at. So there's both sides, but I think it is intrinsically intertwined with with plea negotiations is your status, whether you're in or out.
Dan, I got a question for you though, but is a chronic car thief addicted to meth a dangerous person?
Certainly can be, and it's certainly very, very much of an issue for that neighborhood.
No, I agree. I mean, I think that's really the tension, right? Is, I've had people say, hey, we have an issue with this person in our community. We finally get the police to arrest them. They're out of jail the next day. What should we do? But we have no dangerousness hearings, right? So I don't know who's dangerous and who's not dangerous, right? But I can tell you that if somebody's charged with simple possession of marijuana, I'm not going to argue that they should stay in jail, ever. Right? So that's on the police to bring me something that shows dangerousness. But we've been working really hard on that. Today, our pretrial detention at the jail is the lowest it has been since the jail opened, right? And that's because I personally look at the jail list every day. We try not to keep anybody who's charged with a misdemeanor in jail, but the jail is a living organism, and it has to literally be watched like a baby, right? Or else it will blossom.
Has to be fed.
And we're trying to start
Putting it on a diet.
We're trying to start.
Putting it
I
on
mean,
a
we
diet.
really want only the people who are the most dangerous in there. And that brings up hard conversations, like, is a car thief dangerous? Right? Is somebody who's addicted to who may be, I don't know, but is that a dangerous person? Is that worth $125 a day to the people of Durham County to keep that person in jail? And is it the least most restrictive way to do that person? We have pretrial release services, but we only got a certain number of monitors that they pay for, And we try to use those, we have judges who let people charged with homicide out. Right? So,
D.A. Rollins, did you want to add anything to that before Steve, I know you.
No, let Steve go.
Okay.
Well, here, we'll be on the same page this time. There was a study done years ago in New York City about what was the single most important factor in determining whether judges set bail. And everybody thought it would be prior criminal history, the nature of the charges. What they found was the direct link was if the prosecutor asked for bail. And so this is where discretion, to D.A. Rollins' point, can make all the difference in the world. But I want to mention one other thing. To me, I think we will all agree that the idea of bail, in particular on low-level offenses and the way that coerces pleas, is abhorrent. But here's the interesting question, and New York might be a laboratory for researchers in the room. As we move to a situation where fewer and fewer people, hopefully in light of bail reform, will be held on these low-level offenses, the question becomes, will plea rates at arraignments actually change? And my concern is the institutional expectations are so powerful that this is just a minor case, take the disorderly conduct, take this disposition, even when there are collateral consequences, and even with the fact that it's never been investigated, I have this feeling that the plea rates will not change all that much because of this hydraulic pressure. So yes, it's coercive in and of itself to get out, but I don't know that it's going to lead suddenly to more trials.
One other thing I wanted to follow up on is something that came up in the prior panel, and Scott discussed it a lot, was the information deficit. And I know that New York has just reformed its discovery laws, but I just wanted to hear from all of you, first of all, do you have open file pre-plea discovery, those of you who are prosecutors in your offices? And then just for the audience, do you think this could work in any jurisdiction? Is there, if not, why not? What do you do with cases where there's, concern about witness safety? Because that's the primary reason given for not having open file pre-plea discovery is witness safety, witness intimidation. So Texas has operated under open file pre-plea discovery for a while now, and it's worked fine, but I just wanted to hear from your experience, and are there any obstacles to open file pre-plea discovery?
So North Carolina's an open file state, and I was a criminal defense attorney before there was open file in North Carolina, and now as a prosecutor, there's open file. And, before open file, I would just get some stuff, and nobody would tell me what the stuff was or what the stuff was related to. I just get a stack of pictures of a road. What am I supposed to, know from that? And so I think the question now for us in North Carolina, now that we do open file discovery, my legal assistants upload every piece of discovery that we get. Anything that comes in our office, we use a system called DAS. We upload it into DAS. The defense attorney is notified that it's been uploaded into DAS. DAS has been really helpful for us because we might get to time for plea bargain and see that the defense attorney has never opened that file. Right? And so we use that as part of what we talk about. But so now the question for us is, are we getting all the discovery?
Of course.
Right? So I don't train police. We're trying to move towards training our local law enforcement. But the city attorney trains law enforcement. And the city attorney's idea of what needs to go in the file is very different from what my idea of what needs to go in the file. Right? I want every scrap of paper. They say, oh, my personal notes? Yes. Did you write personal notes? I'm in a homicide and I don't have your personal notes, that you're about to refer to. Right? So
Yes, those personal notes.
right, those personal notes. So everything goes in the file. But open file is great. You can't force defense attorneys to look at it. And there are still things that you're not getting. And there's a question about whether discovery is even, is a trial right as opposed to, so do you have to declare it for trial? Does this have to be, if we're going to plea it down in district court, are you required to have the discovery? So it's a whole thing.
Yes, Seattle's had open discovery for as long as I've been practicing, for 34 years, and in the rare occasion when you really have a concern about witness safety, you can redact certain information about addresses and things, or you can have a protective order that goes with the release of that. Now that, I mean, we've had now for the last 10 years, the battle has been how much does the defendant get to have of that report while they're in jail? And then there's a rule that says the defense is supposed to propose redactions and the prosecutor is supposed to agree to those redactions, and then that can go to the defendant. So it goes all the way to the person who's most impacted by it. And we've taken the common sense steps, I think, to protect people on the rare occasion when it's a threat. I never thought it was a very legitimate reason to never give up discovery ever because there might be a threat, because those are pretty rare. Usually the defendant knows everybody who's going to testify against them. They know more about the case than we do.
When I started at the U.S. Attorney's Office, I had come from a very big firm in Boston, and I'll never forget the first discovery batch I did when I was in the OCDETF unit. I had sort of looked through every single document. I Bates labeled them. I had a cover letter that was like, you know, dear opposing counsel, here are 300, you know, pages of this. I've broken them down by transaction. Here are the dates. And I handed them to my supervisor, and they were like, "Are you what is this? You're not supposed put it in a box and mail it, you know, mail it out." So, yes, I believe we need to be a little bit better with respect to the discovery we turn over. And I'm hearing, of course, from my office that we do this all the time. But when I speak to criminal defense lawyers, they're saying like, no, what's happening is a week before trial, somebody's walking in with all this information that we didn't know about. And those, as we know, are the, 5% of the cases that actually do get to trial. So I think we have to tighten up. What's easier, I think, for me, or hopefully in the future, is because we direct and control homicides, we can say that we have control. I don't pay the Boston Police Department's homicide unit salary, but I get to say who's in that unit. And so if they're ultimately, you know, I have to meet with them and say, you know, Commissioner, this looks good, I think this person is good. When we start, you know, once I get my house in order at One Bullfinch, my 300 employees, we're moving to the Boston Police Homicide Unit and the State Police Detectives Unit, or CPAC, and we're gonna talk about discovery. And we're gonna talk about, I want every single document. We have 1,000 unsolved homicides in Suffolk County. And we are now gonna be announcing, I hope in the next week or so, that all 300 of my employees, we are all in on these unsolved homicides. We're gonna have an administrative review of files, so half of my staff are lawyers, the other half aren't. They're very intelligent people. Jurors aren't lawyers oftentimes. So I have admins, I have victim witness advocates, I have investigators, operations people. They're gonna look through a file and make sure we're gonna now have the same 10 names on the files, right? Is it gonna be medical examiner or autopsy report is one. I've looked through about all these different files. There was a file called Stuff. Like, that was the name of it. So, you know, and again, that's fine, there was stuff in there, right? But you get it, right? Like, let's have all the same things on the files. And then not only are they gonna make sure the file, we've looked everywhere in our control for that file, but we're gonna have a form that we then ask the Boston Police for documents, right? So that we can control this. And this is before we get a detective involved. This is an unsolved, or, you know, a case that hasn't had an answer, a family. Every one of those 1,000 files, I think that's a family that doesn't have an answer yet. So we're gonna be all in on that and looking to try to change things there.
So I want to make sure that we have enough time for questions, but I wanted to ask one last question to the panelists, and it's actually going to be a combination of 3 questions. But first of all, something that came up earlier was about the role of victims, particularly in violent crime cases, when you're deciding about what plea offer to make. You know, are they being consulted? Should they be consulted? You know, what is their role? And then opening it up more broadly, is there a place for broader community consultation on plea bargaining, so extending beyond victims? And I know Steve has talked about participatory defense models, so maybe he can talk a little bit about that, answer that question. And then if each of you can before we move to the audience question, what do you think, if you were to pick one thing, what is the most needed reform of plea bargaining in your view? So, well, why don't we start with Steve this time, and we'll go down. Lots of one.
There is a lot there.
Trying to leave some room for the audience.
Yeah, well, I just want to make sure I have the opportunity to say this. It's someone this morning, I think it was Professor Thomas, talked about it's not plea bargaining, it's plea coercion. I think to a lot of us who practice, it's more appropriately called plea begging. We're begging for information, we're begging for discovery, we're begging for understanding. And it's when a culture shift happens, hopefully we'll be doing less begging. So my ultimate ask is, how do we get around that? And I think the way we get around that is by sharing more information. So when I say sharing information, discovery is not just about when you get something, it's about what. What do you get? So for example, I would love to know, and certainly in some of the more well, actually in every case, police personnel records. And I understand there are union issues, but in New York, that's an ongoing battle, so I'm being a little provincial here. We don't have preliminary hearings. I think police officers should be called to testify on a regular basis about what they did and why they did it. And that can happen early on. And in fact, there are certain prosecutors who I knew, whenever there was an issue, we would have a hearing. So let me just segue real quick there, because I know that's a huge question. I'll get to participatory defense. We hear a lot about resources, that we can't do trials because of resources. And obviously, I get that, but let me just give you one example. In New York, let's just say we took out 150,000 cases. There are about 300,000 cases that came into the system last year. If I told you, let's take out 150,000, do you think we'd have trials? And people would say, yeah, we just cut it in half. Well, the answer is 35 years ago, we had less than that and we had no trials. The court is not designed, it is not evaluated on how well it delivers anything justice. Most criminal courts, it's about efficiency. You read the court's annual report, it's about efficiency. There's not a word about quality or justice. So it's plea bargaining in this context of a court that is not designed to do anything but put people on the assembly line. So in terms of the question, I guess, about ceding authority, and I really do, I defer to the elected district attorneys here, but there is this movement about community involvement, whether it's community court, whether it's court watch, whether it's, I'll give you one example, the joint remedial process in the Floyd stop and frisk case, about having community members at the table about this is how we think we should be policed. Not just we want to bring you into the conversation, but we want to have a say. And the question is there a role, like we're trying to do with participatory defense, to give power to those people who are arrested? Is there a role for an elected district attorney in the office, not just to listen and meet regularly, but to say, you're going to have decision-making authority? And when I say you, I mean the prosecuted, not just people saying, hey, we want the drug dealers out of the building. And I realize that's a heavy lift, but since we're moving that way in other aspects of the criminal court, I think it's something for us to think hard about. What is the role of the prosecuted to think about what they think is appropriate?
Andrew?
I think if I were trying to think of the biggest shift that would be helpful, it would be to recognize just the simple connection between how many people we incarcerate and this process for how we're doing it, right? This is something where within living memory, we had, a seventh the size of our prison population. Our prison population in this country has quintupled, septupled in just a few decades. And we know that that is happening almost entirely because of plea bargaining, right? 95% of those convictions are because of plea bargains. So something has happened just in a generation that has dramatically changed the way that this process, this efficiency-oriented process, has maybe become far too efficient, right? In other words, we spoke in our first panel about efficiency being really important, and I think that there are values to efficiency, but there's a way in which a system is perhaps so efficient that it's just producing way more than it ought to. And then as a result, we need to become somewhat more comfortable with the idea that creating inefficiencies is maybe actually sometimes valuable if it's putting some pressure on resource constraints to force the hard decision. Because it's always hard in an individual case to say, okay, this is the case where I'm going to behave differently. If we can recognize that actually repeated at scale, hundreds and hundreds of thousands of these individual decisions are producing the problem, then we need to find a way to become comfortable with, I think, dramatically fewer cases, right? If that's how we're going to have something that gets us back to where we were just a few decades ago in terms of the number of people who are incarcerated. And I think that you're seeing examples of that in some of the big changes that some of these new progressive prosecutors are putting into place, which are, yeah, I'm going to just stop, I'm going to dramatically cut the caseload of this office. So I think that's an important change that we're seeing happen, and one that is right now happens sporadically depending on the local counties and where these changes are starting. But that's, I think, something that if we're going to ever turn back that tide, needs to become a more common and more widely seen phenomenon.
Can you remind me what the questions were?
So,
Yeah, no, I remember the plea bargaining.
Role of victims.
victims,
Oh, role of victims.
Community and
plea bargaining,
reforms.
community consultation, and then one reform.
Yeah, so one of the big challenges as I came into office was the prosecutor's reluctance to talk to victims about how cases were going. And it wasn't a reluctance to, they were mostly just kind of, if the victim wants this, then that's what we're gonna do. As opposed to really thinking about, is this what is, not justice, but is this what's appropriate in this case? And so I think we are very much concerned about victims in these cases, and there has to be, the prosecutor actually has to have some discretion in what they think is the right thing to do. And so rebalancing that has been an issue for me. As far as community involvement, I am for that, and we're trying to work on some community accountability things in my jurisdiction now. Like, what does that look like for the community to hold the district attorney's office accountable? How do they get information to me about what they would like to see happen? I don't charge in my jurisdiction, the police charge. So there's that tension between, how do we talk to police about what they're charging and how they're charging without them saying, I'm trying to kill them all, which I've heard. I'm trying to get them all killed, or I don't care about, kind of what happens to people on the street, which I very much do. And then the plea bargain. Who was it in the earlier panel that said efficiency is not, the Constitution mentions nothing about efficiency? It was you, right? I talk about that all the time. I don't care. I will try every case, right? We can grind the system to a halt if I don't care. Like, I've got, 3 days.
No, you have more than 3 days. You
I mean,
have
3 years, how many, 3 years, 16 months, whatever, right?
What is that Rent song? 365 days.
Right. So, I can do that. We have.
Whatever it was.
We have 3 sessions of Superior Court every month, and we could just try cases all day, and we can be doing this forever. But the problem is that we got, the incoming stuff, right? And that we should be dismissing a whole bunch of the incoming stuff, but what do you do? Like, it's a thing. I know I say that a lot, but it is a thing. Like, there's a lot of tension in being a prosecutor who wants to do things different and the steamroller of the criminal justice system, right? And so to try to, I think first thing you have to do, like in the office, is try to rebalance that. And that's very difficult, because even people who believe in what you believe in have exceptions. So they believe in what you believe in unless it's carjacking meth addicts in their neighborhood, right? And
So victims of, first of all, prosecutors do not represent victims as their attorneys. We are not their lawyers, but I want to know what they think about a proposed disposition, if it's a homicide, if it's a sexual assault, domestic violence, a violent assault, someone whose life has been changed forever. I think they deserve the dignity and courtesy of being asked about what they think about a proposed resolution. Most of the victims in property crimes are thrilled when you call them up and say that the person who burglarized your house is going to plead guilty and you don't have to come to court. But we still give them the courtesy of that call. The broader community, I'd love to partner with the community to divert cases to the community. I would love to have more of a restorative justice program like in Brooklyn with Common Justice. Love to have more of that, but I don't know how to engage the community's voice in the routine disposition of cases. I'm not sure how that works. And in the reform, I'd like to see more cases tried too. I think we've accepted this equilibrium of like 2 to 3% or even 1%, and that's the norm. And that, again, is a fairly modern, in the last couple of decades, kind of place where the system has come to rest. And so the question is, if you were more transparent, if you put a cap on the price of going to trial, would you do more trials? And would that be such a bad thing?
Dan, I'm just really quickly go back to what you said about most victims are thrilled when you call them and say they don't have to come to court. I don't know if anybody read Michelle Alexander's op-ed in the New York Times a few weeks ago, but she talks about what that in-between place, right, between victims don't want nothing to happen, but they don't always want people to go to prison. Right? And so how do you find the restorative justice pieces or those things in between that has people, where people are held accountable and people feel heard? I am not an abolitionist, but I do think we over-incarcerate people. And so where do we find, most victims don't want people to go to jail. They just want you to, like, acknowledge that you hurt them. And figure out a way to make them whole, and so.
Yeah, I mean, so role of victims, part of the memo, we talked about letting them know all the options as a result of what it is alleged that has happened. And, you know, incarceration might be one of those options, but to your point, restorative justice or community service or some other thing, treat them like they are part of the process. And not, what's funny is, you know, I feel we have a serious duty to make sure they know what's happening. I've made it clear, I don't want them opening the Globe or the Herald to see something about their case and we haven't called them, right? One of the things, the role of victims, the family members of those 1,000 unsolved homicides, one of the things I want to talk about with my office is, you know, when I was running for office, I cannot tell you how many women came up to me and said, overwhelmingly, my son was murdered, insert 7, 12, 10 years ago. I've never heard from your office or the police since the night he was murdered. And I'm like, this can't be right. So even if we call on the anniversary of the death to say we do not have anything to report, we haven't forgotten, whatever it is, we own that, right? We own that. So role of victims, very important. I just wrote a letter in support of a compassionate release from my office, somebody who 50 years prior had been the getaway driver in a felony murder. And even though we're not obligated, I put in bold in that letter, we did notify the family of the deceased. They are not in support of our position, right? I didn't have to do that, and I could have buried it in my but it's bold right there because victims matter. And I say, you know, although their opinion is clearly important to this board, for the following reasons, I'm taking a different position, but you need to know what the family or the victims are saying, right? I feel like that's my duty there. When it comes to community involvement, forget about plea bargaining, just our staff needs to reflect the community. Okay, the criminal justice system is one of the only places where people of color, and I mean black and brown people, are overrepresented. Right? And so when we have prosecutors' offices, progressive, I don't care what your DA looks like, but what you are not going to do is be prosecuting overwhelmingly poor communities and overwhelmingly black and brown communities, and everyone who's in the office is wealthy and doesn't live in the community and doesn't reflect the community. And I don't mean the woman who answers your phone is from that, you know, I mean, that person should get a job too, don't get me wrong, but I want sprinkled throughout my organization, we're gonna have the community represented. I now, as the new DA, said out loud, we're gonna have community meetings. Quarterly, I go out into the community and I explain to them what my office does for like the first 30 minutes, and then I listen to questions. And we have in the back, you know, a table about their case. If they have something specifically about their case, they can write it out and somebody will call them back. Or, you know, expungement or other things, but we are going to be vocal and seen in our communities. One of the things I did on my transition team was I had criminal defense attorneys, I had law enforcement, I had people who had come in contact with the system, and not for a driving offense. 17 years in federal prison, now a law-abiding, upstanding member of our community. There are so many ways we can have the community touch us. And then I did a discharge integrity team with respect to officer-involved shootings that I'm gonna have reporting out, or they're gonna look at them, and me and them are going to speak exclusively. And then the last thing I'll just say is, for reform, I want us to start turning over a lot more information prior to anyone pleading.
Okay, that's great. So questions from the audience?
I had a question for the prosecutors. It's a two-part question. One's on data. So we have a real data deficit in this evidence-based culture in terms of what the original offer might be and what the final plea is. And I think until we get that kind of information, until it's actually kept and turned over, we're going to have a hard time changing the plea bargain. So that's one. The second part is the buzzword of accountability. I'm really bothered to hear that a defense lawyer doesn't open up a file. Something has to be done about that. And that defense lawyer, other defense lawyers who don't do that have to be held accountable, right? And similarly, this notion of having open file is great, but it has to be codified open file, which is like, it has to say specifically what it is you're supposed to turn over. And I want to hear your views on whether there should be a judicial order. In New York, we now have our chief judge issuing what we call a Brady order, which is an order requiring that certain information be disclosed. And part of the purpose of that is to ensure it happens, but it also is to permit that judge to hold that prosecutor accountable. I mean, as you may know, one of the problems in the prosecution of Ted Stevens federally was that there was no order that the judge entered, so the judge couldn't hold those prosecutors in contempt. So I'm wondering about the order and data.
We're working on data with Brandon Garrett at Duke Law School around our plea bargaining. It is tough to capture that data. Any of you guys who do social science research know how difficult it is to do that. So we're trying to think of the questions that we want to ask and how we get to have good data on that. We don't have codified open file in the sense that you have to turn over X, Y, Z. But my assumption is that you should be following Brady. Anyway, we shouldn't need a judge's order to follow
And
Brady.
by Brady, you mean Tom Brady?
No.
It's Boston, Massachusetts, sorry. I'm sorry, we win every time.
Aren't you tired of winning?
It's hard to win all the time.
And so I don't think I would have any objection to our Chief Justice issuing some type of order like that, but I think that's what we're supposed to be doing anyway.
I want to get two more questions maybe so that we can move along more quickly. So there was one over there. Yeah.
Thanks. Somil Trivedi from the ACLU. Thanks everybody for this great talk. We talked a lot about policies and guidelines, and we talked about procedural law a little bit. We haven't talked a lot about the plea agreement itself, which after all is the binding document. I wonder what we can do, or for the DAs on the panel, what you have done to think more creatively about that document so that it can capture some of the values we're espousing, like by saying, telling us a lot more about collateral consequences by, auto-expunging charges after the plea term is served, by setting folks up with services that sometimes only get put into a divergent agreement or get set up after the fact. So, for those who want to see plea bargaining persist, what more can we do to put more skin in the game and make those documents more binding and more fulsome?
Okay. Is there another question we can take to Courtney? I see back there. There's one? Yeah. Okay.
This question is directed to all the DAs, but particularly DA Rollins, because I heard your critique of people who were pro-discretion before. There was sort of a new type of prosecutor in office, and now they're anti-discretion. But I'm wondering also what you think the role is of prosecutors who are kind of in a new model for, and I think this is maybe what Steve Zideman's question was getting to, permanently changing the discretion that prosecutors have. So you absolutely cannot set bail, right? Changing the laws and using your political power to essentially lessen your discretion, but also the discretion of those who follow, who may not use that discretion in the same way you do.
Yeah, so I think we should do both at the same time. I'd be okay with that, but I'm just not gonna wait. It takes too long. The process, people love the way the system is working now. The people overwhelmingly who love it, it's working for them. It's working for them and their family members, or they're the criminal defense attorney that doesn't open the file and it gets paid for every court appearance. But the problem I'm having, ma'am, and I say out loud and I won't ever stop saying it, is the people that lose are poor people, are people that look like me, are black and brown, and men and women, and we are decimating families and generations. And my political power, when you have women of color, overwhelmingly black women that are winning these elections, don't act like I have the full support of my Irish contingent in Boston charging behind, and oh, by the way, I'm half Irish, right? So the 5 people on my panel, I used to jokingly say, I'm more Irish than those 2 Irish people. They were wealthy. My family is Irish, poor Irish, all veterans, serve this country, corrections officers, law enforcement. So don't make assumptions about people, but I will tell you, we don't have a lot of political power. There are people fighting us more so than our counterparts every day, because we are not only usually the first women, which I am the first woman to ever be the Suffolk County DA, but we are double minorities and we are visibly brown. And there are people fighting us that our counterparts might get some pushback about, like, well, that seems weird, but they're not being called radical. They aren't being told to go back to their, or maybe you are, I don't know, I'll check your DMs later, but, go back to your country, death threats. We're dealing with things that other people aren't.
I'll say there's a group called Fair and Just Prosecution. I think there's some people in the audience from that group. They have intentionally brought some of the old dogs like me together with some of the newly elected prosecutors, and my only message to them is prosecutorial discretion is your superpower. Use it. Nobody can make you charge a case you don't want to, and thus you can, in a sense, create the law for your jurisdiction. So I don't prosecute people for possessing small amounts of drugs. I don't prosecute people who didn't pay their speeding tickets and get arrested for driving. I don't prosecute a whole bunch of juvenile cases. I send them other places. If I had to go to my legislature and get them to agree with me, none of those things would have ever happened. The downside of it is it doesn't necessarily endure once I leave. Hopefully I lead by example and people go, well, that made sense, let's keep that policy, and maybe someday the legislature will catch up with us. Gentleman from the ACLU, you had a good question. I didn't want to gloss over it. The plea agreements are boilerplate, they're pro forma, the colloquies are like this, it takes 30 seconds to go through it. Often now we're seeing, in the era of the new administration particularly, all sorts of Padilla concerns about the immigration consequences. And people are coming back to my office saying, we're about to get deported for this thing, and while, yeah, the record, you could probably defend the record because you went through all those rote things, we didn't know that we were going to get sent back to a country that we haven't been in since we were children, leaving our American-born children orphaned here. Can you do something? So now it's upon the prosecutor to try to find some fancy way to withdraw that plea and plead to something that's not going to raise the attention of ICE. And so there's a lot more that we can do and should do, because I don't think people fully understand. But that might make that 30-second hearing last like 3 or 4 minutes. So.
Yeah, and I have a stack of motions for appropriate relief just about immigration issues.
Absolutely.
And so, and what was the other?
Discretion. Do you like your discretion?
Yeah, I mean, I love my discretion, actually. I love my discretion a lot. I'm from a community that's had about, let's say, 80 years of black political power. I'm not the first black prosecutor. I'm not even the first black woman prosecutor in my jurisdiction. And pretty much everybody in my jurisdiction in power in the criminal justice system looks like me. Our senior resident Superior Court judge is black. Our chief district court judge is a black woman. Our police chief is a black woman. Our sheriff is black. So it's not just about the people looking different, it's about the people thinking different. And so I'm with Rachel. Like, when I was running my campaign, there were a lot of people, including the incumbent, who said, well, you just can't do that, right? All the stuff you're talking about, you just can't do. but I'm a constitutional officer with 100% discretion in what I choose to do. And I have been pushing the envelope on what I use my discretion to do. I think people are just not used to using their power, or they, this is their career job. They need to be in this job for the next 16 years, so they don't want to piss people off. I don't really care about pissing people off. I'll find a new job. But like Rachel said, it's really important to push this while we have it, because these are people's lives that we are talking about. It's not a law school hypothetical. There are many, many collateral consequences, especially if you're a black or brown person in the United States, to having been convicted of a crime, to having even been charged for a crime in North Carolina, because those don't come off your record. If a case gets dismissed, it's still on your record. And no employer, no housing provider is going to take the opportunity to really look deep into that to see that your case was dismissed. There are lots of people out there who don't have criminal records, and you can proceed with those people. So it's really important for us to really push that. We also have boilerplate plea agreements. I hadn't actually thought about that, but I'm going to think about how we do that in our boilerplate. Yeah, do that. I mean, we have a administrative officer of the courts form that we have to use, right? But there's like a space in the back, right? There's some lines that just people never fill in, and so maybe we should fill in the lines with something. Yeah, so let's talk about it.
And we're working, in the memo, we have a collateral consequences section of the memo, but we're working with Harvard Law School on creating a document so that not just my ADAs, and the memo was written, by the way, in a way that not just lawyers understand it, but I really believe all of your staff should understand it. Like, we can't do our job without the investigators, victim witness advocates, everyone. So this is written, in language that everyone should understand, and for the community as well. But yeah, we have, I'll end there.
Well, I'm afraid we're out of time, but thank you all, and thanks for.